Right. Good evening, ladies and gentlemen. Well, I say good evening. I'm using the term loosely. But welcome to the second part of the Planning Committee meeting. There isn't a fire drill planned this evening. If there is, the fire probably won't catch. But, so if the alarm goes off, it will be a genuine emergency, and we'll follow the Democratic Services officers out as they find a safe route out of the building and hopefully come back and tell us what it is. Right, the Council is hopefully recording this meeting this evening. Can I ask if anyone else is intending to record this meeting? No? Thank you very much indeed. Right. We have two sets of agendas this evening, so I will be referring to both sets of page numbers. Starting with the first agenda item, item 1, apologies for absence. None. So hopefully we haven't got any substitute members.
For Councillor Perry for Councillor Stockwell.
Thank you very much.
Apologies, Chairman, I was in another world.
It's very easy to do on an evening as trick as this to drift off. Oh, thank you. Notification of visiting members. I don't see any visiting members. Item 4, items withdrawn from the agenda. I don't believe there are any, which is good as it's a short agenda. Item 5, any business the Chairman regards as urgent, including the urgent update report as it relates to matters to be considered at the meeting. It's agreed we take the urgent update report insofar as it relates. Thank you very much. Item 6, disclosures by members and officers. Are there any? Councillor Harwood.
Thank you, Chairman. There's quite a lot going on in my professional life at the moment, so if you see me looking at my phone or I suddenly have to shoot out, it's not me, it's the flooding and trees falling over and everything else, but apologies in advance.
Thank you, Councillor Harwood. That's very useful. Item 7, disclosures of lobbying we'll take with the relevant application. Item 8, to consider whether any items should be taken in private because of the possible disclosure of exempt information. There are no such items as far as I'm aware, so we will be taking the whole of the agenda as such that it is in public. And we now turn to the long list of planning applications for this evening and start with the Stables, East Court, The Street, Detling, which is item 21 on either page 132 or page 1, depending which set of agenda papers you're looking at.
Thank you, Chair. This application is for the construction of a pair of semi-detached cottages. The application site is in two parts. There's a northern part where the new house is going, and the southern part where some new parking is going. The housing involves the demolition of the garden wall along the boundary. That garden wall is not listed. In terms of the second part, the entrance to the parking area is through an existing a gap in the wall. And there's also a listed wall further to the south along the corner here. In terms of the aerial photograph, the application involves the demolition of the kennel buildings, which are the white L shape at the top of the photograph, and the two houses are going in this location. In terms of the parking are on the south side of the existing two houses. You can see the existing access. There's existing parking associated with a neighbouring dwelling. Just behind the houses, you can see an existing wall, and there's a gate there. And the application involves setting that wall and gate back behind the back wall of the existing house. For the purposes of the Maidstone local plan, The application site is in the countryside within the Kent Downs AONB and the Deckling conservation area. In terms of the proposal, the proposed houses are the same design, scale and siting as approved under an extant planning permission, which expires on the 23rd of September this year. The reason for the second application is the parking, which was previously located in front of the dwellings, has been relocated to the south side of the existing properties, which are now to the side of 1 to 3 East Court cottages. Just looking at the parking area, you can see there are two parking spaces for one cottage here, and 2 further spaces at the back of the site for the second cottage. In terms of the photographs, this is looking towards the side of the existing dwelling. The proposed houses are the far side of the buildings that you can see there. You can see the entrance to the parking area, and the listed wall is over to the right-hand side of this photograph. Just a more closer view of the entrance. The proposed parking will be located behind the walls that you can see there. And then inside the parking area, the wall and gate that I mentioned earlier on, visible here, is going to be moved back to allow parking in the space there. This photograph is looking towards the kennels that are just being removed. So the back of the existing houses, and the parking area is over to the left-hand side. This is the front of the area where the new houses are going. The existing wall, you can see, is going to be knocked down, along with the kennels behind. This is the image of the proposed housing. As mentioned earlier, this is the same form design as previously approved. The 2 houses would be formed of red stock bricks, hanging peg tiles, and plain clay roof tiles. The pictures have a steep roof ridge, taking account of the gradient of the land, with a barn hip. As mentioned earlier, the proposal is similar to the extant planning permission. It is not considered to adversely harm the character of the appearance of the countryside or the AONB, or result in adverse impact to neighbours, and is considered in accordance with the Maidstone local plan. The Office's recommendation is to approve, subject to planning conditions. Thank you.
Thank you very much, Mr. Ryan. If you'd like to refresh the public's memory on how the public speaking works.
Good evening, ladies and gentlemen. We have now reached the part of the meeting where members of the public can speak. When the chairman calls your name, please step forward to the table in front of you and press the middle button on the microphone. The ring will turn red, and you will then be able to start speaking. Your time is shown on the screen there. You'll have 3 minutes. And at the end of your time, the chairman will indicate that your time is up. Please then press the middle button again and return to your seat. Thank you.
Thank you very much indeed. Our first speaker this evening, apologise if I don't pronounce this correctly, is Ms. Furs.
Since many objections have already been lodged, all of which I fully support, my own objections are mainly with regard to the new application, which has the addition of parking provisions now relocated to fall within the boundaries of my property, Tudor Gate. At the same time, I would add that this is the second attempt by the applicant to turn this area into a parking lot. These proposed parking provisions are totally impractical, as they are situated some considerable distance from the new housing. They lie behind a single-lane entranceway, and two of them directly opposite my property, in sight of my front door and windows. The designated bays for these are narrow, inadequate, and unsuited, with no room for manoeuvring that would not involve driving across my garden or driveway, where my car is usually parked. What appears on the plans to be a wide entrance road is in fact only 3 metres in width, as the remainder belongs to Tudor Gate and comprises its front garden. The actual entrance between two listed walls is only sufficient for one vehicle and restricts entrance and egress to single vehicle movement. 2 further spaces provided by moving the present gate to the stables would only add to the confusion. This would in fact bring the total number of vehicles using this single-lane private entrance road to 8+, including those at the stables itself, and would result in vehicles queuing to back out onto the street, which I believe may be contrary to the Planning Service parking guidelines. The original drive was designed for just 2 properties, the stables and Tudor Gate, both of which share equal rights of way. The resultant noise, fumes and disturbance of traffic movement, attendant doors closing and unclosing of vehicles, would result in loss of safety and quiet enjoyment of my property and garden, as well as the existing cottages, also including the safe parking of my own vehicle, and would, I believe, therefore be contrary to Policy DM1 of the Maidstone Local Plan 2017 and the National Planning Policy Framework 2012. It is also probable that because of the distance from the new build, owners would still park their vehicles on the street and simply encourage their visitors to use these spaces as a convenient car park, which would indeed be its appearance when viewed from the road. The area for parking bays 1 and 2 is currently grassed with shrubs and plants and forms a pleasant outlook, as well as being within the Detling Conservation Area, and I would therefore ask that serious consideration be given to refusing this application.
Thank you very much. It's perfect timing. Councillor Howes, Detling Parish Council, please.
Thank you, Chairman. Evening, members. I'm here to represent the views of Detling Parish Council as a councillor. We would first like to state that we firmly support the objections that have been registered with the council about this development. These were registered on the original application, but we acknowledge that there is a valid planning consent for these 2 houses. Our current concern is a strong objection to the proposed parking amenity area for these 2 houses. It is some little distance from the proposed dwellings, and therefore we are concerned about how it will be used in reality. Will they always park in their parking spaces? We doubt it. This area is already subject to quite a lot of car parking, both by residents, by customers of the public house over the road, and by walkers and visitors, and increasingly by commuters into Maidstone. We think this will only exacerbate the problem. As regards the design, we have serious concerns about the reality of parking spaces 3 and 4, about whether having actually accessed those parking spaces, which will prove difficult in one case, whether you can actually get out again and do a 3-point turn to come out facing the road. We respectfully ask members to consider the application and to refuse it, and ask the applicant to provide a better scheme which recognises both the conservation area, the area in which this is located, and the needs of the residents adjoining this proposed parking area. Thank you, Chairman.
Thank you, Councillor. Right, can we just clearly, when we're looking at planning applications, land ownership is an issue that isn't strictly a planning consideration, but we just need to check that the right certificates have been served on the right people, given the points being raised. Mr. Ryan.
In terms of the actual planning application, the applicant has submitted certificate B, which means that the applicant doesn't own all of the land that the application is on. So, as far as I can see, that is that certificate has been served correctly.
Okay. So what the objectors are saying then may well be true, that to access the parking area would involve using other people's land. That does not necessarily invalidate the planning application, of course. It certainly wouldn't, provided the correct certificates have been served. It would possibly make it difficult to deliver in practice, because common law remedies and other legal remedies might be available to prevent it actually being, shall we say, brought to fruition. But of course the planning committee can't take that into account. That would be for the residents and their legal advisors to pursue at the relevant time. So we'll have to focus on the planning issues. Councillor Clark, I think you were about to say something.
I was, Chairman. I noticed when we, in the paperwork where the Conservation Officer and Landscape Officer 4.04 raised no objection under 15/503966. Well, I'm mindful of the fact that there is a listed wall at this point, and that this obviously will affect the visual amenity in the vicinity of the parking, and it concerns me somewhat that we haven't had an updated view from a Conservation Officer.
Yes, I did note that in terms of the actual papers, and we have sought a verbal view on this latest application, and that they're happy in terms of the impact on listed wall, because I think there is a separation from the listed wall, and if in terms of the servicing of the parking spaces, if that is done in a sort of grasscrete material or something similar, they're happy in terms of that impact.
I would say to that, Mr. Ryan, that if we are sort of basing our approval, shall we say, on the Conservation Officer's view that a grasscrete material is necessary, then we should be conditioning that rather than leaving it to the applicant's good wishes. Councillor Harwood.
Thank you, Chairman. I understand that the civil issue around land ownership and the other thing, which is really out of our hands. However, in terms of amenity impact, replacing the landscaped approach to the existing residence properties with a car park, there is a significant amenity issue there that we, as a planning authority, can consider. That's one thing I wanted to raise, and you're absolutely right about the surfacing, the landscaping for the car parking areas, and ensuring that the entire area does not become a parking area full of vans and things parked on the grass and so on. I mean, if there are no barriers, you can mark out a parking area. The reality is the whole area which will be deemed a parking lot will be rammed, essentially. So I think there's a practical issue. Coming back to the other element of this application, which is the removal of the car parking from in front of the proposed two new properties. When this application came before committee, there was an awful lot of discussion about impact of air pollution and noise pollution from Detling Hill, which is just the other side of the acoustic fence. There is an opportunity from removing the parking in front of the houses of putting in a fairly decent landscape screen. and potentially something like a privet or a hornbeam or a beech hedge or something. And because landscaping for that part of the site would not have been considered as part of the extant permission, we will need to update the landscaping to ensure that we get an appropriate domestic boundary planting on the new frontage. Thank you.
Councillor Prendergast.
Mr. Ryan, before I continue, can you just go back to the parking from the outside? The first picture, please. No, the one that shows the entranceway.
The stone wall.
Yeah. Okay, so it's the second wall that's going to be knocked down, I take it. Moved backwards onto those grass verges, whose ownership we're saying the applicant is unsure about and has served a Certificate B notice. Is it that grassed area there?
In terms of the application, that they filled out Certificate B, it's not clear in terms of what land is owned by someone else, by someone other than the applicant. It's just part of the land which is within the red line boundary. Part of that is owned by someone other than the applicant. So it's not specified where that land is.
Of course.
Yeah, the Certificate B is simply a declaration by the applicant that they have served on another landowner. They don't have to provide evidence of title to back it up. It's normally only when we get to a Section 106 agreement that legal looks at the title and actually establishes who owns what.
Indeed. Right. Yeah.
Continue then, thank you. Okay, so I will say at this point, because you didn't ask for declarations of lobbying, that I have been extensively lobbied on this. But I'm going to say it now, and clearly I represent that area under a different authority, and obviously there were concerns regarding highways on this. And my understanding, I mean, I will say now that I've come in with an open mind and I haven't expressed any opinion either way. But my understanding was that, according to the land registry, it was very, very clear whose ownership that land is in. Now, I know you've said that a Certificate B has been served, but my understanding is that that may be KCC land and that has utilities underneath it. So... okay.
Please.
In that case, I retract that, but I was just making sure. Okay, so I know that we've got extant permission on this, and it's been previously agreed, but my recollection of that last application was that we considered it under very different circumstances. We considered it under the last local plan, and we also considered it at a time when we didn't have a 5-year land supply. So, as you're always reminding us, Chairman, we must look at each application on its own merits, and I'm choosing to look at it this way. So, I can see that there are certainly issues here with SP17 because this is certainly outside of the village boundary. And I know that we've accepted that in the past. I'm not sure that, I know previously with residential amenity, with parking in this area, whether it's 4 car parking spaces or 10 car parking spaces, I can still see that there will be an impact on residential amenity because we're now moving from in front of those houses to that particular area. And some of the speakers have, I think, expressed their concerns very, very well. I think those were the residential amenity and the fact that it is now in open countryside and the fact that it goes against our policies. And I think the parking is going to be a real issue, and I do not see that this equates to a sustainable development under these circumstances. So those are the points, but I'll see what other members have to say. Thank you.
It's fair to say that if this were a fresh application and there were not an extent permission, that most of what you said would be pretty inarguable. Unfortunately, having an extant consent is a fairly substantial material consideration. However, Having said that, I would take some convincing that we are anywhere near dealing with the loss of a residential amenity issue in relation to the car park. I think that we are some way away from resolving that point. So whether that can be conditioned, I think it will take a lot of very careful working out conditions. So if you are going with a refusal, I think it's the residential amenity issue, which was, of course, a consideration in the previous refusal that we had on this site. Councillor Round.
Thank you, Chair. I'm afraid I'm going to pursue the parking issue further. Again, not so much challenging, questioning or anything else. It's probably more a case of confusion. Looking at the map, the overhead picture that we saw, this is in fact an entrance to another house. So therefore, because this is an entrance to another house, theoretically, those cars are going to get in somebody's way. That's my perception of it. And that just confuses me even more. To me, we're defying logic. This is a building put on one side of one building, with parking put on the other side of it, which, quite frankly, is going to get in somebody's way. Whatever the planning rules are, logic is the problem that I have, and confusion is what manifests. And I'm still somewhat finding the whole concept very, very weird. Thank you.
Thank you, Councillor Round. Councillor Powell.
Yeah, thank you, Mr. Chairman. It's a very strange. In fact, it's quite weird, this application. There's so many different things in it that I just can't fathom out, and I think I can share Councillor Round's confusion. I often get confused, actually, on this committee, but I'm sure I will leave here tonight feeling even more confused. But one question to Mr. Ryan. I understand that the boundary wall is going to be removed. Is there going to be a boundary that replaces it? Because once you actually move or knock down that hard boundary, then it opens it up to anybody. I mean, will it be used as a grass verge, maybe, where cars park on it?
So you're asking in terms of the wall being moved. Is the wall being moved? Yeah. Well, the actual front boundary wall is not. There's nothing happening with the front boundary wall, but it's the internal wall, existing internal wall, which you can see in dotted lines on the plan, is just being relocated backwards. So you can see the existing boundary wall is in the sort of dotted lines, and that's just been moved backwards further into the site.
Councillor Powell, you're not on.
Sorry, this is all part of the confusion, I think. And is that wall that's being moved backwards actually in the land owned by the potential new applicant, or is that being moved back into someone else's land? I know we were talking about a civil thing earlier on, but it seems to be there's lots of activity happening on land that is not necessarily part of, well, certainly to be submitted before this application. It just seems, I can't quite get to grips with it. So if you could explain it to me just once again, all this moving around on different people's lands and accessing through someone else's drive, all very confusing.
All of the works that are proposed are within the red line boundary. So the red line boundary shows the extent of the plan application. As part of the application, the applicant is required to submit a certificate of ownership. If the applicant owns all of the land that is within that red line boundary, then they fill out certificate A. If they don't own all of that land, then they have to fill out certificate B and inform other owners. In this case, the applicant has filled out certificate B, But what we don't know is which parts of that site the applicant doesn't own.
Exactly.
That's where the confusion is. So are we in a position as a planning committee to have the potential to actually grant planning commission tonight on land that isn't even owned by the applicant?
Bring the legal officer in a moment, but yes, we can grant the planning consent on. You could apply for planning consent on my back garden to build a church or a pub or whatever. It doesn't mean that you'd actually get to build it, because your right of access, your right of way, etc., might not be allowed. So you can get planning consent on my land, but hey, you might not be able to build it.
Yes, the issue of the land ownership is not the concern of this committee, provided it's a valid application, which we believe it is. Then we are assuming, for the sake of argument, that the applicant can do what they need to do with that land. We're actually not concerned with that question. If some of the land is owned by somebody else, that's a matter for negotiation between them, whether the permission is granted or not.
So if we could just stay off that issue for the further on. Councillor Borton.
Thank you, Mr. Chairman. I think that's helpful, and I'll try and get off it. When I first saw this, I thought, oh, well, there's an extant permission anyway. They've submitted an application that's the same design, scale and siting. Not a problem, really. I agree with a lot of what Councillor Prendergast said, but the reality is that extant permission will trump any other of those factors that were mentioned before. So I don't think we're in a position to refuse anything based on the design of the house at all. What we're really looking is at the parking and whether the parking's suitable. And looking at the parking, I've got lots of sympathy with the residents here. I think the applicant's been a bit too ambitious, really, as to how many cars he can fit into quite a small bit of land, irrespective of whether he owns it or she owns it or not. And that's the reality of the situation here. My question for the officers is really, obviously, we're talking about a pair of semi-detached cottages, so 2 cottages and 4 parking spaces, the 4 new ones put up there. If the applicants would have put in, let's say, 2 parking spaces, which would have been slightly more sympathetic, and he might have had to modify the design a bit, that, in my view, would have been far more likely to have prevented any problems than the design that they've come with at the moment. Because I look at that design that we've got on, and that site map that we've got on the screen at the moment, and I don't know who lives at number 3 East Court Cottages, but I feel very sorry for them because they're sort of being boxed in at the moment. And if that isn't a residential amenity sort of impact, then I'm not quite sure what is, because I don't think there's any form of landscaping which can mitigate that, to be totally honest. So I'm mindful that that's my thoughts at the moment, Mr. Chairman. Obviously, I'll wait to see if anyone else has any other thoughts on this, but I can't support any form of refusal based on the house or the design at all. It would have to be about the impact of this parking design on the neighbours, which I think is probably this committee's best route forward if it were minded to go for a refusal.
Okay, well, if we can move on to Councillor Mumford. Yes, I have seen you before, Councillor. It's much easier without all the people.
I'm quite small, I will excuse you. Right, I've listened to it. We've got 5-year housing land supply. This is most definitely a windfall. It's not an allocated site. It's in the ANOB. Do we need it? No, we don't need it. It's not. We're not in a position without a 5-year housing land supply. Do we have comments on the parking from the Conservation Officer? I don't think so. I haven't read them. I've got something in a conservation area, and I believe the parking will harm the setting of the conservation area. So, after listening to everyone, I think that I would like to propose we refuse this application based on I believe it's paragraph 33 of the MPPF, damage to the conservation area, which is a heritage asset. And also, I believe there is a problem with neighbour amenity to do with the parking, and so I would take advice on what policy that is within the local plan. So that's my proposal, refuse on paragraph 33 of the MPPF based on the parking destroying the setting of the conservation area within the ANOB.
Yeah, I'm not sure about that. We'll have to come back to that in a minute. I think Councillor Prendergast was seconding that. Do you wish to speak now, please?
Okay. Right. Having heard everything, I do accept that with the extant permission, I think we're going to struggle on the basis of SB 17 for the houses themselves. But the parking does remain an issue. I cannot for the life of me understand how we're going to build 2 4-bedroom houses, 8 bedrooms in total, and provide 4 parking spaces. That, to me, is unsustainable in the first place, and I fail to see how that meets any parking standards. And those 4 spaces, I know the chairman feels that I'd have a hard job justifying, but I still think under point 4 of DM1, it's not going to be 4 vehicles moving through that. It's going to be substantially more, and I think that's going to be a problem. I agree with Councillor Mumford about this, how it will impact on the setting of the conservation area. And also, I'm really, really concerned that having 4 parking spaces for properties around the corner uphill is unsustainable in that how is anybody who's disabled or elderly or with children or heavy shopping ever going to manage to park in those spaces and walk uphill and round the corner? It just doesn't work. So I'm happy to second Councillor Mumford on this. Thank you.
Councillor Cox, please.
Thank you, Mr. Chairman. A lot of times this committee sees drawings from either highways or whatever, they at least pass their view on them, where we've seen how vehicles will reverse out of proposed spaces, widths of roads, and I'm afraid I really can't see how the parking space 3 can actually get out of there, because if the gate's shut, they've got to go over one of the speaker's garden. Why have we not got the proper drawings showing us the paths taken by the proposed parking spaces? Could I hear about that first, please?
I'm sure you can. Do we know? While that's being looked up, do you have any other points you want to ask, Councillor Cox? So we look those up at the same time.
Obviously, visiting this site, one would wonder why the land opposite the back of the Cattery as it is now, where there's an inlet where the old road used to go up the hill, hasn't been proposed, because the width of that road is wider and then smaller, and I'm sure that if this was actually looked at as residents' parking area or a residents' parking zone, that we could get some parking spaces in there and not stop the flow of traffic around the corner to East Court, I think that is. So I really wonder whether this shouldn't be looked at a bit further. I know it sounds like we're putting the fate off, but I don't think every stone has been unturned here, and I think there are other options that may make the proposal of the extant application worthy of us passing it. But at the moment, I can't see that, but I would be interested to see what Mr. Ryan has to say.
Members, we may have problems with the application, but what we can't do is turn it down because we think a better application could be arranged. We have to determine the application we have in front of us. In terms of the tracking, Kent County Council or Highways Department would not normally provide tracking data for what is such a small application, essentially. So that's why we haven't got it. But Councillor Clark, and then I'm going to seek to try and wrap it up because a motion has been moved.
Thank you, Chairman. I think we should consider the impact on amenity of the adjacent house. My gut feeling is that this type of arrangement is the sort of place, the sort of setting where cars go to die. And not only do they go to die, if I was buying the house on the corner and this is my parking space, I would consider that if I need to work on my car, that's my parking space to work on my car. And I think the house is somewhat besieged by these, by the fact that we've circled them with parking spaces that we really aren't that comfortable about. So I think that we should consider the effect on the conservation area and the impact on the amenity of the house owner at that point. And potentially other house owners, given the fact that we don't quite know how we're going to park in number 3.
Not to mention the fact, Councillor Clark, that actually, if you look at that, there's potential for actually ending up with another vehicle or two parked in. I don't know how you'd actually control that. So I think that the risk of trying to rewrite what has already been proposed.
Also, very quickly, I brought up the conservation area document on the NBC website, and when we're looking at this area, there are so many small subtleties about the reason why it should be protected, should I say, and I think this is significantly more harmful than some of the things in that document. So I really do think that if this comes back, we should have a full appraisal by the conservation area officer.
I would say that the stronger of the two grounds for potential refusal, or rather the most straightforward ground, perhaps rather than stronger, is the residential amenity ground, because that was the basis of a refusal earlier. Admittedly, it's for fewer spaces, but I think we could argue that by nature of the setting, location and layout of the potential parking, the difficulties of landscaping it adequately or screening it adequately, and even limiting it to the actual 4 spaces that are actually proposed, that we could argue it actually still represents a significant potential detriment to residential amenity. And then I think, given the relative closeness of the conservation area, that a second-degree effect of an uncontrolled parking area on the conservation area would be a reasonable argument. I don't think we've got anything else we can really look at, because there is an extant consent, and so all the other issues that we would normally, and I do agree with you, Councillor Mumford, Councillor Prendergast, that we would take into account normally, we have an extant consent, so we can't really go into that. So if we can just go with the 2 grounds. Anyone want to add anything? Councillor Hall.
It was just that small point around the fact that where we're losing the car parking spaces from the front gardens, that there is no detailed landscaping or anything shown to compensate for that, and perhaps we should be seeking through the wording associated with any refusal that a domestic boundary planting scheme is required, but particularly because it is on the edge of the historic village and the proximity to the main road.
So I think that would be an additional possible landscaping reason for refusing this application, that they have not provided a landscaping scheme for the front, which would, would be appropriate. I think it would be appropriate. Mr. Ryan? Because we would have sought one normally. That's okay. Right, is everyone clear? Right. Right. By ground 1 in relative area, right, is that because of the form, location and layout of the proposed parking area and the lack of opportunity, the lack of landscaping shown in the proposed layout, there would be a continued detrimental impact on residential amenity. Words to that effect. 2. Of course you can.
Sorry, if we could just add what it said in the last refusal, the associated general noise and disturbance would result in a poor level of amenity.
Noise and disturbance can be added in, I'm sure.
Sorry, and headlights from turning movements. And I think the point that you made has been made by others around the fact that I cannot see any way of controlling the parking to ensure that it's just those spaces are used needs to be feasible.
I think that's we've got another sentence here. To the effect of the effect on residential amenity. The detriment on residential amenity is further underlined by the risk of substantial noise and disturbance associated with the proposed parking area, or words to that effect. Councillor Mumford, we don't want to make this too complicated.
No, without making it complicated, it's contrary to DM1(4). And it relates to vehicle movements.
Thank you very much, that's helpful.
DM1(4), it does specifically say vehicle movements, and I think that's what we're saying.
Yeah, thank you very much, that's very helpful. Ground 2 was due to the layout, due to the location and layout of the location and layout of the proposed parking area would have a negative impact upon the setting of the conservation area. And the associated disturbance would have a negative effect on the setting of the conservation area. Noise and disturbance. And 3 was your point, Councillor Harwood, about the lack of a landscaping scheme for the front of the property. It's a minor point, but I think we might as well include it because we would have asked for it. Should have asked it, really. And it's not there. Given the setting of the OMB and the sensitive location. Right.
Sorry, Chairman. The reason I was delaying is I was just checking the planning application and can confirm that it is white space in front of the 2 houses. So I think we really do need to say that that is a key omission, and that absence of a landscaping scheme for the front of the the proposed buildings is
which would in effect mean we could end up with 2 parking areas.
Yeah, absolutely.
Which might be worth mentioning. Thank you, Councillor Harwood. Right. All those in favour of the recommendation as proposed, seconded and amended? That's everyone. Thank you very much. And as Councillor Prendergast reminded me, we should take declarations of lobbying. Anyone other than Councillor Prendergast? I've been lobbied. Everyone apart from Councillors Perry and Broughton. I don't know why you were left out, because given how important you are. But just for reference, it is always useful to make sure that substitute members are lobbied as well, just for future reference to it. It is a frequent omission that people do. Yes, the application is refused on the grounds of potential impact on residential amenity, impact on the conservation area, and the lack of a landscaping scheme to the front of the property, which is an omission due to its potential effect on the AOMB and the fact that it could also thus become a second parking area. So there we go. Of course, that does mean the default position is the extant position that already exists. So they can actually build something there. Right. We now move on to Southways in Sutton Valence with the tree preservation order, item 23, pages 156 or item 10, page 18, depending which agenda you're looking at. Appear to be having a minor technical issue. That's so unusual. Right.
Yes, just to explain the tree preservation order. A provisional order was served in January 2018. They have a 6-month expiry period, which will be July 2018. The serving a provisional order obviously gives the opportunity for the owner or anyone affected to raise objections to the confirmation, and that's the process we're going through now. The tree preservation order is served on 4 Wellingtonia trees, as indicated in the photograph. These were originally retained in a planning permission dated in 1987, when the houses were actually granted planning permission. And there's a planning condition on them that be retained, but obviously that's now 30 years old. So what we've decided to do is serve a tree preservation order to sort of reinforce the reason that the trees are protected is their public amenity value. The trees are sited to the west of the dwelling, in the front garden. The tree nearest the garage is what's called label T1, and then obviously continues to T4, which is the tree furthest from the house. T1 has some lightning strike damage, but the tree officer is of the opinion that all of the trees are structurally stable, no evidence of any damage being caused or risk of damage being caused, and although there have objections been submitted, the tree officer considered the public amenity value warrants the protection of the trees. Obviously, if members were to go with the recommendation and confirm the order, the owner would there be in their rights to put an application in to carry out any works or removal of the trees if they so wish, and that can be looked at in detail in terms of any evidence of damage or structural instability. So the recommendation is that the Okay. Recommendation is that the order be confirmed. I say that has to happen for the 18th of January, otherwise the protection will fall away.
Thank you very much indeed. Mr. Chapman, please.
Members of the committee, thank you very much for the opportunity to address you this evening. My name is Alex Chapman. I'm a chartered town planner with experience in the public and private sector, and I'm a relative of the owners of the property. Often in the development proposals that we bring forward, we advocate a well-thought-through landscape strategy for the added value that brings to a scheme and the contribution that good planting can make. And it is around the contribution that planting can make and their amenity value that brings on to the grounds for objecting the continuation of the order. Firstly, in the appraisal in the officer's report, there has been no consideration on the actual amenity value of the trees. Secondly, we believe that the trees actually have an adverse impact on amenity to the property and the surrounding area. And finally, there is a conflict between the trees and the property that under today's guidelines wouldn't be acceptable. So just looking at the officer's report, whilst he has highlighted the trees are in good condition and that there is a visibility from within the cul-de-sac and glimpsed views from the main road, just because they are visible and in good condition does not mean that they are of high amenity. There has been no assessment of that in the report. In fact, we would contend that 4 giant sequoias over 20 metres have an adverse impact. The overshadowing on the property restricts the daylight to the certainly the lower floor. I remember on many occasions visiting grandparents and often thinking how gloomy it was in those rooms. And there is damage from the roots to the pathways there. These are trees that are also having an impact on the setting and the environment within the cul-de-sac. They are clearly of a scale that is not fitting for front garden plots. And I think, finally, what we would just highlight that we would, in any landscaping proposals today, you certainly wouldn't put giant sequoias with their root protection zones within this sort of distance of properties. So on those grounds, we would respectfully request that the order is discontinued. Thank you very much.
Thank you. Ms Simmons, an objector, please.
Thank you. My name is Sarah Simmons. I'm a director of Savills.
I'm not sure you're on, are you? Can you?
Yeah, I am. Sorry.
Oh, right.
I'll speak louder.
No, you were not speaking into the microphone. You are now, so...
Okay. We were instructed to market 5 Southways. We launched the property onto the market last August at what we felt was a competitive price. All the feedback was very, very consistent and large concerns over these Wellatonia trees. As you can see for yourself, look at the height of them from the where the top of the roof is. And everybody was basically saying that they were dangerous, they had big concerns, and would not move forward. So what we decided was, with the family, that we would speak to Maidstone Borough Council to see whether there was a way forward. And we met with Nick Gallivan in November. And actually, at that time, there were some branches and some limbs on the ground, on the floor. And we did raise concerns with him then that we were worried that this was going to be a problem. We actually had then, from November, absolutely no communication from Nick Gallivan. We tried 10, maybe 12 times to contact him just to see whether what was happening, what was the path forward. And then in the January 2018, he informed us that there was going to be a TPO served, which wasn't particularly constructive. In April of this year, we spoke to the vendors and said we felt that to try and get around this and try and find a buyer for the house, that we would reduce the guide price by 5%. Obviously, they weren't very happy with this, but to try and find a buyer, they were, with our advice, they were happy to do this. We did actually come forward. There were 2 buyers who would like to buy the property, and they have put offers forward, but both offers are between 4% and 5% lower than the reduced price, and neither party will move forward with the trees as they currently stand today. So at the end of the day, we seem to have a property that's unsellable, and in our view, they are dangerous, and particularly as they're non-indigenous trees. We'd like to, agree with this TPO being not carried forward. Thank you.
Councillor Harwood, I think you're indicating.
Yeah, thank you, Chairman. I just wanted to put this application in some historical context, because I remember when this application came to the Old South Area Planning, when this estate was originally proposed. And I remember the role of Sutton Valence Parish Council and Councillor Baxter back in the days when Sutton Valence was represented by another party. And it's a very interesting one, because there was a lot of discussion about the proximity of these trees. However, the applicants, when they built this new estate, were saying, oh no, they're going to ram the houses in, they're going to build them really close to the trees. And it's an interesting case where you've got 150-year-old trees and then kind of 30-year-old houses that have been shoehorned in. And you could see this coming a mile off, but the applicants, and to a certain extent buyer and future buyer, beware, because those trees were important trees on the boundary of the old Victorian garden, which did stand there before the housing estate did. So I think it's really quite difficult to now, you know, these trees unquestionably have a very significant landscape value, and if we put in houses too close to trees, we're going to have these problems down the line, and we see it all over the place. Walderslade, Woodlands of Vinters Park, we see it time and time again. I think the trouble is that we're on a very slippery slope in terms of principle and precedent. If we start to remove these TPO trees a few years down the line, you know, if as part of the application that they had actually, you know, addressed this issue, we wouldn't be where we are today. So therefore, if there is a genuine safety issue, if there is, then the TPO does not stand anyway. This is purely a landscape issue that we're dealing with in terms of the TPO legislation. So I'd like to move that we confirm the order tonight. Thank you.
Councillor Clark, you were first, I think. Do you wish to speak now?
I would second it, and I reserve my right, Chairman.
Councillor Mumford, did you wish to speak? Right. Councillor Harwood puts his finger on it, I think. I remember many similar discussions in the past, and the fact of the matter is a tree preservation order does not prevent works being made should they be necessary. And all it does is require the applicant to set out the reasons why they are necessary and how they are to be done. So it gives the planning authority control over what needs to be done. There are potentially, I'm not saying necessarily in this case, but potentially there are things you can do between nothing and removing a tree. There are potentially things you can do. I think it is clear that at this stage, if the TPO is not made, there will be no trees there. That is not necessarily the outcome that could be secured, might not be a solution. And if we go down this path with all situations, what we're going to have is a lot more houses squeezed in inappropriate locations and a lot fewer trees. So I have to say that it would be very bad practice not to confirm this TPO at this stage. That does not mean that we will not necessarily grant consent for work should it be necessary. Any further speakers? Councillor Bolton, as you haven't spoken.
Thank you, Mr. Chairman. I went and visited this site at the weekend because it's not often we get a TPO application here, and I thought, what's the concern about? So I looked in there and I thought, and I'm looking at that picture now, and I'm kind of slightly unsure how there's not a safety issue here. I appreciate what's been said, but these are ginormous trees, particularly tree 2 in the middle there, if they go 1 to 4 left to right, because if branches came down, they go right on top of the house and they could cause some structural damage. I'm perplexed, if I'm totally honest, Mr. Chairman, about how we've not got a safety issue here. And it's for that reason, having made sort of a visit to the site myself, I am not as gung-ho as other members of this committee in just granting a tree protection order. I appreciate a lot of what's been said already, but I do think that at times we need to look for a common sense solution. And a common sense solution would be some sort of... I agree, there is a need for trees here. There's a need for land for a different type, but it's evident that this is just sort of totally out of setting with the house that's there. And I do worry for the residents of the house, whoever they are, if I'm totally honest. I can't for the life of me see how there's not a safety issue here, I'm afraid.
If there is, we have to set this TPO aside. I actually say, though, that the trees were there before the house, so it's a question of which is out of location. Councillor Prendergast.
I was going to say pretty much what Councillor Bolton has just said, but is there scope here for us to defer this? And we're hitting deadline time, are we? Because I'm particularly concerned about trees 1 and 2 and the safety implications, as Councillor Borton has pointed out, and also residential amenity. I know they're wonderful trees, and it's a very grown-up thing to do to plant trees. And you know, I've planted some recently within our grounds, and it's quite frightening to think that one day that will be the end result. But surely, no, it shouldn't be. But I do have concern for the residents on this as well.
The report's quite clear. There are no grounds for deferral. It's confirmed the TPO or not. Councillor Harwood.
I think there's a very important legal point to be made here. A TPO is not on the tree per se. It's on the land that the tree sits on, and says that a tree in that site provides the landscape value. If there is a safety or any other concern, and the tree is removed, the TPO ensures that there is replacement landscaping, which is another critical point. And I just come back to the point that these trees are no bigger now than they were in 1987 when the permission was given, or later than that when the houses were actually built. There was an application to build the trees that close to the land. Yeah, build the houses that close to the trees.
Councillor Mumford.
I'm sat here, again, listening. Is there a common sense solution? I think the developer is totally wrong for squeezing those houses behind those trees. People have bought the house and known that there's a TPO, or there's reasons and conditions for those trees to stay there. Looking at that picture, is there a common sense solution of confirming the TPOs except for what I'm going to term as T2? I'm just throwing that out as a common sense solution.
I think there's Councillor Harwood.
I do have some concerns about messing about with it, because those trees will be completely enmeshed in terms of their roots. And if you take one, a coniferous tree is not like a deciduous tree, which will go on living and the other trees will help it out and so on, and it will keep going. What will happen is that it will contract and heave, and you could see the stability of the surrounding trees go. You know, it's a woodland species that's meant to grow with other trees of its species, and that, you know, they're tall and thin because they do grow quite tightly if you go to Northern California. So I think we're stuck with what we've got. Unless there's a safety issue that emerges, then unfortunately it'll probably be the whole lot that go, I reckon.
As I say, an application for works can be put forward under a TPO. They can take all sorts of forms, so it wouldn't stop. You know, it would just give the council control over what is actually the outcome. So an applicant could make an application for works under a TPO of quite substantial nature. We would just have to determine that when the application is made. Any other? No, in that case, it's been proposed and seconded the TPO be confirmed. Those in favour, please indicate. Those against? Any abstentions? I don't think there were. No, that is confirmed. Oh, sorry, Councillor Powell, you are abstaining. Thank you very much. I thought the numbers didn't add up. Thank you very much for that. Right. We have a number of appeal decisions on the agenda. Does anyone wish to ask any questions or comment on the appeal decisions? Any comments? No? In that case, so by and large, a reasonably satisfactory outcome. Number 2 was variation of a condition, which was slightly annoying, but otherwise not a bad set of outcomes. In conclusion, then, as we reach the end of this municipal year, in terms of the Planning Committee, may I thank members and officers for their input throughout the year. And I'd like particularly at this point to thank Councillor Round, Vice Chairman of this committee, for his support to myself and to the committee throughout this year. Thank you very much, Martin. I have appreciated it. Enjoy the rest of this lovely evening.